Imagine a distillery in Haryana selling whiskey. Their label explicitly reads, Scotch-Style Whisky, proudly made in India. They declare their true geographical origin right on the bottle. It is an honest label, but is it legally safe? No. If Scotch whiskey is a notified geographical indication, that label infringes despite declaring its true origin. Under Section 22, subsection 3, using terms like kind, style, or imitation triggers an automatic infringement for notified goods. Welcome to Patentworld-ai, Lecture G5 for the Trademarks Agent Exam 2027. Today, we unpack the rights conferred by registration, the three distinct modes of infringement, the absolute ban on assignment, and the collision zone where GI law and trademark law meet in Sections 25 and 26. Section 20, subsection 1 states that no person is entitled to institute any proceeding to prevent or to recover damages for the infringement of an unregistered geographical indication. However, Section 20, subsection 2 clarifies that registration status does not affect the right of action for passing off. This common law remedy remains available for both registered and unregistered indications. Mirroring Section 27 of the Trademarks Act, GI law establishes formal registration as the legal prerequisite for an infringement suit, while maintaining the passing off remedy as a secondary recourse. Moving to Part 2, Section 21 establishes that registration confers two distinct legal rights. However, unlike standard trademark law, these rights are split between two different types of participants. Clause A deals with enforcement. The right to obtain relief for infringement belongs to both the registered proprietor and the authorized user. Clause B, however, is more restrictive. The exclusive right to use the geographical indication belongs to the authorized user alone. Section 21, subsection 3 provides for concurrent use. Where multiple persons are authorized users of identical or nearly resembling GIs, none gets exclusivity against the other. Each user, however, has full rights against third parties. This creates a unique structure. The proprietor, typically an association or government body, manages the registration and has the right to sue, while the individual authorized users are the ones who commercially apply the GI to their goods. Under Section 22, a registered GI is infringed by a non-authorized user in three specific ways. Mode 1 is false origin, geographically misleading the public about the true place of origin. Mode 2 covers unfair competition. The act includes passing off and any act contrary to honest practices, such as creating confusion with a competitor's establishment. Mode 3 addresses the literally true use. This occurs when a user applies a GI that is technically accurate about the origin, but falsely represents that they originate in the registered territory. Section 22, subsection 2, allows the central government to notify specific goods for additional protection. Applying for this higher tier requires Form GI 9A and a fee of 12,000 rupees. Under subsection 3, the standard for these notified goods becomes absolute. A non-authorized user infringes even if the true origin is clearly stated, or if the geographical indication is used in translation. For candidates, the key takeaway is that for notified goods, using the GI alongside terms like kind, style, or imitation is an automatic infringement. No evidence of public confusion is required for the court to act. Section 22, subsection 4, provides a limited exception. Lawfully acquired goods can be resold or repackaged without infringement, unless their condition is impaired. Separately, Section 23 dictates that the certificate of registration is prima facie evidence of the GI's validity. The Act treats geographical indications as a matter of geographic purity. Once goods are notified, the law prohibits any comparative marketing using that indication. Section 24 prohibits the standard commercial transfer of rights. Notwithstanding any other law, a registered GI cannot be assigned, licensed, pledged, or mortgaged. This ban exists because a geographical indication is collective property. It belongs to the producers of a region and is tied to the land itself, which prevents the right from being privatized or sold away by a single entity. The only statutory exception occurs on the death of an authorized user, in which case the right devolves on their successor in title. This contrasts with trademarks, which are freely assignable corporate assets. Under the GI Act, the right is inseparable from the producers of the territory. Part 6 addresses the interaction between GIs and trademarks. Section 25 gives the Registrar of Trademarks the authority, acting sua motu or by request, to refuse or invalidate a trademark that contains a geographical indication. Refusal is mandatory in 2 cases: if the trademark would mislead the public as to the true origin of the goods, or if the goods are notified under Section 22, subsection 2. Section 26 establishes protections for established trademarks. The first protection applies if a trademark was used or registered in good faith before the GI Act commenced. The second protection applies if the indication had already become the customary name of the goods in India by January 1, 1995. The third protection ensures that any person can continue to use their own name or the name of their predecessor in business, provided it is not used to mislead the public. Finally, Section 26, subsection 4 sets a limitation period. No action can be taken against a conflicting trademark 5 years after its use became known to the GI proprietor, provided there was no bad faith. Memorize these 2 specific statutory metrics: the 1st of January 1995 cutoff and the 5-year limitation period. These are the legal boundaries that protect legacy trademarks from new geographical indication claims. Section 66 establishes the jurisdiction for these matters. Any suit for infringement or passing off must be instituted in a court not inferior to a district court. Under Section 67, the available reliefs include an injunction, covering both ex parte and interlocutory orders, along with the plaintiff's choice of either damages or an account of profits, and the destruction of infringing labels. Section 67, subsection 3, provides a defense for innocent infringement. If the defendant proves they were unaware of the registration and stopped use immediately, the court will not grant damages beyond a nominal amount. While these enforcement mechanisms are similar to those found in trademark litigation, they can only be accessed by meeting the specific registration and geographical origin requirements of the GI Act. Let's conclude with a rapid-fire recap of the core data points. Question 1. Can you file an infringement action for an unregistered GI? No, only passing off actions are maintainable. Question 2. Who holds the exclusive right to use the GI? The authorized user. Question 3. Name the 3 modes of infringement: false origin, unfair competition, and literally true but misleading use. Question 4. Does Scotch-Style on notified goods infringe? Yes, under the absolute protection of Section 22, subsection 3. Question 5. Can a GI be used as collateral for a mortgage? No, Section 24 prohibits all such agreements. Question 6. Who has the power to refuse a trademark that consists of a GI? The Registrar of Trademarks. Question 7. What is the generic cutoff date? 1st January 1995. Question 8. What is the limitation period to attack a trademark? 5 years from the date the use became known. Question 9. What is the lowest court that can hear a GI infringement suit? The district court. That covers G5, one of the most significant chapters for the 2027 exam. Next, in G6, appeals, offenses, and the GI agent system. This is Patentworld-ai.